Good to see everybody again after a quick break for Joe's presentation. I'll be talking a bit now about how it is that we can hopefully improve our relationship in some ways with our parents. We know that can be a bit of a hot button issue nowadays. We know that there is a lot of turmoil politically across the country and also in the state. And so we're seeing more and more groups getting involved in the education process. A part of me says, for how many years have we been begging parents to get involved and please help support our schools? And now when they get involved, we can't just say, oh, no, not like that. That's not what we meant. Well, that's not how it's going to work. We have been asking our parents to be involved in our schools, to partner with us in educating their children. We know that takes a lot of trust. Their kids spend more time in their school during their waking hours than they do with their parents. And so your staff get to see their kids more often than their parents do, most likely during the school year. And so that takes a lot of trust to ship your child off to somebody else to watch over them all day long while they're doing the other things. So now that parents are getting involved, we really do need to find a way to make that a strong collaborative environment or relationship so that we can kind of have some smooth interactions between our staff and between our parents. So why does having a good or a positive relationship with parents matter? Well, again, there's lots of reasons. Parents are our customers. How many of y'all have billed yourselves as schools of choice or used that phrase when you're making your recruiting pitches and things like that? We say we are a school of choice. Well, if we want parents to choose with their feet to come to our school systems, we need to treat them like our customers, our partners. Their satisfaction matters to us. If they get dissatisfied by us or with us, they can take their feet and they can go exercise their school choice ability and go to somebody else's school system and take their children with them. So again, we need to make sure that we are having a positive collaborative environment with them so that we can hopefully foster an environment where they want to have their children continue with us. And best case scenario, they go home and they tell their neighbors, hey, my kid's at this school, it's incredible, y'all should really think about bringing your kids there. And so they can be recruiting tools in a way as well. So we have to remember that as we are interacting with our parents, whether you're in an administrative role or if you're conducting business in a board meeting. We need to be professional, we need to be polite to our parents and do our best to help them feel welcome and help their children feel welcome as well. That does not mean that we have to listen or I guess necessarily take action on everything that they want to do. Again, we realize there's going to be differences of opinion. And just because a parent doesn't like a particular way that a teacher is doing one thing, or maybe doesn't like a particular curriculum course you've made, that does not mean that we need to adopt a new textbook or a new curriculum or have private teachers for every single student, things like that. Again, we're still a public school. We set our operational protocols and we follow those, and we don't necessarily have to always go along with everything parents say or what they request. But at the same time, when there is a disagreement, we don't want it to become personal. We don't want it to become volatile. We want to still have that positive working relationship so that we can continue that customer service protocol and make sure that we have happy families. A lot of times, I think we have a tendency to get a bit competitive. If we have a parent who makes kind of repeated complaints or is always calling the school asking about things or whatever the case may be, we may naturally start to get competitive and say, well, I want to show you that I'm right. I'm the one who's doing things the right way. It's more important for me to win, quote unquote win, by showing the parent how they're wrong and not that I am right, rather than it is to try and build that positive relationship. So hopefully we don't turn our interactions with parents into really competitive type things where we're always trying to one-up each other or prove that the school is right and the parents are wrong or vice versa. So sometimes it can be helpful just to kind of reframe those conversations. When we talk about or the parent complains about something that's going on in the school, we can maybe turn that around and show that how our program is actually working and serving our students and things like that. And so kind of reframing that conversation can be really important to make it a little bit less adversarial so that we don't wind up with a significant number of complaints or written grievances, things like that. It's also important because we need to make sure that we're valuing the people with us. I guess that kind of goes along with the first point there, how these parents, they're our customers, they're our partners. We do need to have that collaborative relationship with them. And then we also do need to consider fairness. Sometimes a parent is going to bring something to our attention and say, hey, teacher X, Y, or Z is doing something that's not right. And we investigate and we find out, well, actually, teacher X was doing something that isn't right. And so we need to take corrective action. or we need to consider fairness, not necessarily always just staying entrenched and saying, it's my school, it's our school, we're gonna do things our way, and if you don't like it, you can go down the street somewhere else. No, we still do need to consider fairness and what's right. If we do have staff members or things that are going where we have a harassing environment, or if students are being bullied and a parent brings us a bullying complaint and we find out, well, yeah, there is actual bullying. Don't just sit on that and don't try to brush it under the rug. We do need to take action and do what's right and what's just and what's fair and equitable for our students as well. You can see, check the news and see lawsuits that are filed against school districts or other school systems across the state where they say, hey, the school, we told them time and time again that my child was being bullied, and it continued and the school did nothing. We don't want to be those schools who just kind of get those complaints, and even if we know that, yes, something bad happened, we don't do anything to fix it. That's not going to be good for us moving forward. Need to make sure that folks feel safe and empowered while they're in our schools. Our students and our parents and our employees as well. So we need to do what's right by everybody. So what difference does having that kind of collaborative relationship with our parents make? Well, for one thing, it helps us be more efficient. If we're able to partner with our parents, that can cut down on the number of disputes between the parents and the school. And so we're not always having to field calls telling us what we did wrong, and then we can focus more on what it is that we're doing right and making sure everybody's taking care of their regular job duties. It's a great opportunity, again, for us to be able to show our grows and glows, or we can talk about here are the steps that we've made. Maybe a parent did bring a concern to our attention where we did need to make a change, and then we can then kind of talk about how we changed and reinforce here are the steps that we took. And now the parent is that much more happy. We're not having to continually address those particular issues, and we can move on from there. Tying into, voting with feet. If we have a school environment where parents feel like they're going to complain to us and we're just going to tell them, go away, we don't care what you say, well, that's not going to help your brand or your reputation. I know that word, your brand, is a big thing nowadays. I'm not really into the PR side of things so much, but I know that branding is very important, and you don't want to be known as the school that doesn't like parents or the school that parents don't like, because that is not going to help bring those feet to your school. So it's a great way that we can really manage that brand and reputation, not just for the parents, but as we mentioned here, our reputation with the state. Have y'all ever had a parent file a TEA complaint against your school? I would say if you're answering no, well, probably just wait. It's going to happen. We have seen in our practice a marked increase in the number of parent complaints that are going to TEA. So it is happening more and more often. And I don't think we want to have the reputation with TEA where they start an investigation and they found out that, yes, this school learned about something that was wrong but didn't correct it, and they're continuing to deal with the same issues over and over again, these complaints. That's not going to make a good reputation for us with TEA, which can make things more difficult down the line if we're looking to expand or those type of things, or during your renewal cycle. You think they're going to look more closely at your renewal application if they have a stack that's this thick of complaints that have been filed by parents in the past year. They're going to wonder what is going on. So having a collaborative relationship with parents not only helps that relationship, but also helps our brand or our reputation with TEA. With other parents as well, like I mentioned, you don't want your families to go home and start telling your neighbors, this school is horrible, they hate kids. That's not going to be good. You want your parents to be your best supporters and to tell their neighbors and their friends and their family members, you should really check this school out. They've done great work for my child, and they do great things for yours as well. The news media. Anybody ever seen negative news coverage of a school system in the state of Texas? I mean, shocking, but it happens sometimes where there are negative news stories that are out there. And so if we can have a collaborative relationship with our parents, we can reduce the likelihood, or hopefully reduce the likelihood, of them going to the media to complain that we're doing something incredibly wrong. A big one, especially if you're looking to open a new school and you have to go to a city council and ask, hey, can you help us out with this zoning permission? Or you can help us out with those type of things. What if all they ever hear about your school from parents is this is a horrible school? You think they're going to be willing to work with you in opening up a new facility or making it easy for you to pass inspections, things like that? Probably not. So your reputation matters. And parents have a voice, and they're becoming more and more savvy in finding different ways to use that voice. Whether it's by writing emails to their elected officials, showing up to public meetings or showing up to city council meetings when your school is applying for a zoning permit or things like that to contest These people are terrible. Why are you going to let them open a school? Sending complaints to TEA. As we talked about in our earlier session at Open Meetings Act, a parent coming to a board meeting and recording things and publishing things online. Or going on Twitter or X or Facebook or whatever it is and posting their personal thoughts about the school. So again, parents have a voice, and there are many more avenues for them to use that voice now due to technology than there was in the past. And so if we create a culture where they don't like us and they feel that it's an adversarial relationship rather than a collaborative one, they're going to express that. And it's going to be so much easier for that voice to get out there. All right. I know I talked earlier about, we don't want to put it into a circumstance where we feel like we're trying to win a complaint or win a grievance. But there are some circumstances that we can say this is how we are going to lose that battle, or we're not going to have a collaborative relationship with our parents if there are concerns. The first one is general compliance. If you are not following the law, your parents are going to know about it and they're going to complain about it, as they should. Again, if you're mistreating their kids, they should let you know about it, and that's a valid thing to do. And if we are not following the law, we are not going to win that complaint. If a parent goes to TEA and makes a bullying complaint, and TEA does an investigation and finds out that our campus did not follow David's Law procedures, that we didn't issue the proper notifications to the parent of the bully, to the parent of the victim of the bullying, if we didn't do an investigation, if we didn't make findings, and we did nothing, well, we're going to lose that, and TEA is going to put corrective actions on us to make sure that we don't make that mistake again. If a parent has a special education student and their IEP requires that child receive certain services, and if we go a year without providing those services, well, they're going to file a complaint, and a hearing officer is going to say, charter school, you did not follow the law. And the parent had, again, a right to complain about that and a right to expect us to live up to our end of the bargain in implementing those special education services. And since you did not offer those services, you're now going to have an opportunity to redo them at your own expense with no additional funding. And you better do everything you can to catch that child up to where they need to be in a short period of time. So following the law is incredibly important, because if we're not following the law, our parents are going to figure it out, and they have many different avenues, not just politically speaking or public relations speaking, but in going to TEA and going to the courts and going to those various avenues where they can get substantive findings against us. Along with not complying with the law is also not understanding the law. And so if your administration doesn't know what Title IX is, that's going to be an issue. If your administration doesn't understand what's required in special education programming, that's going to be a major issue. So we need to make sure that our staff are trained and they understand what the law is and what it is they should be doing. Anybody have board policies? Any of your schools have policies? I certainly hope that, yes, we do. We have policies. We have policies. Do our policies do us much good if everybody ignores them and nobody actually bothers to follow them? Well, no, not really. And so once more, if our policy, if you as the board has told our school officials, this is how we operate the school, and they're not following those directives, well, that's another opportunity for parents to catch that. Your policy manuals are public information. Anybody can ask to see those at any time, and they can review them at any time. And if they find areas where we're not following our policy, that can easily lead to a grievance circumstance where they come to you and present something that says you are doing something wrong in the school setting. And if we're ignoring our policy or violating it, that's going to be a grievance that we're going to have a hard time denying. A big one that we see on our end is inadequate documentation. So again, coming back to compliance, if we have special education services, we need to be sure that we are documenting when those services are provided, and that is accurate documentation. If it's not in writing somewhere, it really didn't happen, or at least that's how we think of it as attorneys. If it's not in writing, it didn't happen. Otherwise, it's just I said, they said, and that's it, and we're never really going to know what happened. I'm just going to kind of skip through some of these other ones on here until we get to some additional stuff. Dealing with particularly sensitive or major compliance issues, either not asking for a legal opinion if you think it's necessary, or relying on poor legal advice. Google is not your lawyer. I know sometimes it may seem that way. You can find a lot of things on Google. AI is getting smarter in a lot of ways, but it's not an attorney. And I don't say that just because I'm an attorney. I know I'm not the smartest bulb in the bunch all the time anyway. But again, it's important to know who to go to for good advice and find competent advice for your school and your board to have. And then if your attorney gives you advice, you might want to pay attention to it and not necessarily let it go in one ear, out the other, that type of stuff. So again, be cognizant of that. If you have major concerns, major compliance issues, ask the experts, ask for help, ask for people who can give you good guidance on that. I'm not going to go through the rest of those. Y'all can check those out later. All right. So is it fun when a parent brings a complaint to us? I would say usually not. We like to think that we're doing things the right way and that we have a smooth running operation. And when someone comes to us and tells us, well, no, you're making mistakes, you're not doing things right, sometimes we can take that personally. And it's not really fun necessarily to go through that. But there are some things that we can do when a complaint comes in to make it not as painful or unpleasant of an experience. One is going to be consistency and fairness. It really is important that we treat people consistently and fairly. If we don't, we wind up in circumstances where we just end up with more complaints. You likely could have opportunities or chances or circumstances in your school where you get a group of parents who say that my child is being treated differently because of the color of their skin or because of their sex or because of our race or national origin. You are treating students who look one way differently than how you treat students that look the other way. And if we have a circumstance or a practice where we do treat people differently, well, that's going to stick out to them. And so we need to be sure that we are being fair and consistent in how we treat things, and that we don't only respond to complaints raised by our favorite parents or the ones that we like, but we legitimately look at all the complaints and make sure that we're doing our best to be fair and consistent in those. It's also important for us to actively listen. Once more, if we get a complaint that comes in, usually not the best idea to just write a quick email back saying, thank you for your concern, we did nothing wrong, this matter is closed. Well, that's not going to help resolve anything. We need to be actively listening, paying attention to what the parents are telling us so that we can decide or make a consistent and fair determination as to whether or not anything inappropriate occurred or if a policy was violated. And so we need to be actively engaged in responding to those concerns. It's also important for us to try and maximize the good in the process, where once more, if we are meeting with the parents, we can talk about the exceptional things that we're doing as a school and how we're working to keep people safe or to treat people fairly, things like that. Documentation, once more, if it's not in writing, it didn't happen. So it's important to document our steps as we go through our investigations or through reviewing these concerns. This last one on here on this particular side, when it doesn't hurt, sustain it. If a parent brings a litany of 7 complaints, and some of them are pretty significant, but maybe there's one where, on this particular day, the teacher didn't let my child have a snack in class or whatever. Everybody else got what my child didn't. Well, we may not want to ever admit that somebody messed up or did something wrong in class, but if we can say, well, these big 6 other things you mentioned, we didn't find any evidence to substantiate that, but we do see that, on this particular day, your child didn't get a snack. Well, that doesn't really hurt us to acknowledge it. I don't think anybody can sue us for not giving their kid some animal crackers, things like that. But it at least helps the parent realize that they've been heard, that we listened to them, and that we legitimately looked into everything. And we recognize, yes, this thing did happen that you claim happened, and we took steps, we're taking steps, we're telling our teachers. Again, just remember, check and make sure that all your kids who are in class that day get a snack, that type of stuff. And so if there's nothing wrong with sustaining or agreeing with the parent when they bring a complaint. If they have a legitimate claim, there's nothing wrong with recognizing that and letting them know that, yes, that's a legitimate concern, and here is what we're going to do to fix it moving forward. That can really help to help contain situations and not let things kind of escalate and have feelings continue to boil over. It's important for us to, have a practice of welcoming complaints, even though that sounds kind of weird to say it that way. But we want to be sure that, hey, if you have concerns about your child's safety, if you have concerns about how our school goes, please bring those to us. Again, we're partners. These are their kids. They're going to have questions. They're going to have concerns. And we want to have that open door policy to the most extent possible. Again, not so that they can come and be there 24 hours a day telling us what we're doing wrong, but welcome them to say, yes, if you have legitimate concerns, please bring those to us and we'll do our best to fix them or resolve them. Don't ever just tell somebody something in writing as well, or in person, verbally. Never make a decision orally or just verbally. Once more, if there's a grievance or written complaint, have a written decision so that we can address and document what it is was said. That prevents circumstances where we wind up down the line in either a TEA complaint or an OCR complaint or in litigation, and the parent says, principal told me X, principal says, no, I said Y, but there's nothing in writing. Well, then it's going to be up to a judge or a jury to decide who they like better and who they're going to believe. So it really is important that we communicate in writing with our parents when they have concerns so that we can help to set our narrative in place and show them what it is that we're doing so they can't then come back and try to, play with our words or say that we said things that we did not actually say. As we talked earlier about board meetings, how when we're in a board meeting, those are your meetings as members of the board. Well, when we have a conference with a parent about a complaint or a grievance, that is your meeting as a school. That is still a school meeting. And so you can set the expectations where we're going to be here. We're going to be professional. We're going to be polite to each other. It's not going to turn into a shouting match. But please share your side of the story, and then we'll do our investigation and get back to you. And then ultimately, the most important thing that we can do really is to allow the parent to be heard. Sometimes that's all it takes, is to have a meeting with the principal or with the superintendent, or to allow somebody to come to a board meeting and talk to the board to share their side of the story. A lot of people really just want to be heard. And if they've at least expressed their opinion or their feelings, they're going to be much more amenable to kind of let things go because they feel like they've been heard. Okay. So, does anybody have a complaint process for your school? Anybody have a parent or student complaint process? Hopefully everyone is saying, yes, we do, because those are important. I'll probably mention this again, but once more, our state rules tell us that our board of directors has to be the final say, and so we want to make sure we have a process so that if a complaint gets to your level at the board, you have a record of some sort where you know what the actual issues are. And if you're going to be asked to decide whether or not the school acted appropriately, it's nice to have that record to see what the investigation found, to see what the, whatever statements we gathered, whatever evidence we have, so that you can make an informed decision as to whether or not you are going to support that parent's grievance. There's lots of different ways that we can structure that grievance procedure. Informal complaints, that's always a nice way to do it, where we don't necessarily have, big, long written stuff going back and forth, but we can have a conference with somebody, just bring them in to talk with the teacher, talk with the principal, try to work things out that way. And then, of course, once we have that meeting, we follow up in writing to document what was discussed and to document if there was a resolution made. This is what we're going to do. Here's how the school is going to respond and our plan for moving forward. So put that in writing again, even in those informal processes. If that informal process isn't successful, or if the parent just doesn't want to go that route, we still have our formal grievance procedure where they can, again, fill out your school's grievance or complaint form. That complaint process can be structured a lot of different ways. Most schools will have roughly 3 levels of the complaint process, where maybe you start at level 1, which is a complaint to the principal or another campus administrator. If the parent is not satisfied with that decision, they can then go up the ladder to the superintendent's level or somebody else who's one of the administrators of the school. And then if they're still dissatisfied with the result, they can ultimately make it to y'all at the board of directors level and have that be kind of the final decision there. It really is important that we do follow what is in our policy when it comes to our complaint process. That is something that TEA could look at and say, well, you never followed the process. You need to go back and meet with the parents, all that kind of fun stuff. So it is important for us to know what's in your policies, and once you know what's in your policy, to follow it. Excuse me. There are also going to be different processes depending on what type of complaint is being made. I spent a good chunk of time yesterday talking to your principals and other staff about Title IX. There is a whole separate complaint process for allegations of sexual harassment or discrimination based on sex that has one particular avenue of complaint or investigation. If we have a complaint of discrimination based on race or disability, there's a separate investigation process there. If we have a complaint about a disciplinary decision, we have a different process there. So again, there are lots of different ways or avenues that complaints can be made, and it's important for us to know what the appropriate avenue to respond is, and that we actually stick to that policy and follow through with it. So it's important, once more, to know what's in your policy, to know what's in your handbooks, and when a complaint comes in, to make sure that we are following those steps. Important things for us to do. Make sure that we are not retaliating against people. Once more, you may take it personally. Maybe you're a superintendent and you get a complaint saying that you've done X, Y, and Z mad. You're like, no, I didn't make that. I'm not perfect, but I didn't make those mistakes. So now I'm going to look out and I'm going to start being nitpicky. And anytime your child acts up in school, I'm going to look for ways to, expel them, whatever the case may be. No, we don't need to retaliate. We need to make sure once more that we are fair in how we treat our parents when they come to us with concerns, and don't try thinking of ways to make their life miserable because they are saying that we did something wrong. It's also important that we make sure that we understand exactly what the complaint is about. Now, the specifics matter. If we get a really generic complaint that we don't know what in the world they're talking about, well, how are we going to investigate? How are we going to have a meaningful decision about what it is that we need to do? So it is important that we make sure we understand the specifics. And if we're not clear about something, either ask the parent to complete another grievance form or complaint form, or when you meet with them in a grievance conference, let them tell you exactly what it is that they're concerned about so we know the specifics. We also have the flexibility to tell parents you can't keep complaining about the same thing over and over and over again. If we've decided an issue or a particular incident, once it's resolved, once it's been to the board, that's it. We're not going to continue to go back and address the same thing over and over again. Or if a parent makes 5 complaints in a week, all kind of the same thing, well, we can consolidate those into one complaint process so that we're not having to have 5 separate grievance hearings or 5 separate appeal hearings before the board, things like that. So we have flexibility once more to consolidate things if there's lots of complaints, or to tell a parent, we've already addressed that. This was our final decision and we're moving forward and we're not going to continue discussing that particular concern. It's also important to recognize that parents and students do have the right to be represented during these hearings. If there's going to be a grievance conference at the school, they can bring an attorney. That's totally fine. If they want to have somebody else there, I've seen, family members have been there on behalf of parents. I've seen religious leaders come to these meetings or these conferences to try and work things out with schools or between parents. So the parents can have someone with them there to support them and to give them advice, whether that's legal advice or not legal advice. They can have someone there. And conversely, as the school, you have the same opportunity or the same right. If you get notice that a parent is bringing an attorney to a grievance conference, you can absolutely contact us if we're your attorney, or contact your other legal counsel and say, we'd like you to be here for this meeting because the parent is bringing an attorney, and we can make that happen, or your attorney can make that happen. So that's an important thing to remember. Timeliness is important. A lot of times your complaint process will say that a parent needs to raise a concern within 10 days or 7 days or whatever the case is of a particular event. Well, if a parent waits 6 weeks, 8 weeks, 12 weeks to file a grievance, there could be an opportunity for us in our policy to say, well, we appreciate your concern, but you did not file it in a timely manner, and so we're going to dismiss the complaint. You can still do some checking to make sure that nothing inappropriate happened, but we may be able to use our timelines to not have to do a full-blown investigation in all circumstances. Just be careful about that, though. Make sure it's not a serious major complaint, and that if we dismiss the complaint for not being timely filed, we don't set ourselves up for claims on the back end that we failed to take appropriate action, things like that. But in addition to checking the timeliness of when the parents filed their complaint, you also better be sure you understand your timelines for responding to the complaint. And so if your policy says that you have to issue a written decision within 10 school days of a complaint, be sure that you issue that decision within the 10 days of getting the complaint. If you need more time, it's perfectly fine to tell the parent, we're still investigating, we're still reviewing, we will have a decision for you by this date. And then hit that date. Make sure that you're following those timelines. Because it's not fair for us to tell a parent, you have 7 days to file something, you wait until the 8th day, so we're going to ignore you, but then we take 6 weeks to issue a decision on our end, and we just say, deal with it. We can do whatever we want. That's not how things work on our policy. So understand the timelines, remember the timelines, and comply with them. I mentioned earlier that one of the major things we can do is also to allow the parent to be heard. So how do we do that? Well, we can set up those grievance conferences or those complaint conferences where they can meet with the principal, they can meet with the superintendent. If they go through all the appropriate channels, they can eventually come to the board and present to you and share with you what it is that they would like to see be changed. So those can be very important meetings to hold. I guess I've already talked about checking the timeline, but once more, if you need additional time to make a decision, let the complainant know that you need a little bit more time. and then hit that timeline. Don't continue dragging it out forever and ever. All right, a few more slides that we're going to do some hypotheticals or kind of check y'all's knowledge as far as what it is that you might or how you might handle certain complaints that come in. So what are we going to be doing when we're actually responding? This is kind of steps that we can take when responding to a complaint. One important thing is for us to provide a summary of the issues that the parent brought. If the parent raised 6 issues in their complaint and our decision or our response only touches on one of those complaints, what is the parent going to think? They're going to think you ignored me. You didn't listen to me. You're not paying attention. You're trying to cover something up. You're trying to hide what happened. So if there are 6 issues in the complaint, our decision needs to touch on each of those 6 issues. We need to make sure that we are summarizing what happened and make sure that we address each of those concerns. It can also be important for us to reaffirm who it was who filed the complaint. I've seen instances where, I'll just change some names, but perhaps there was a parent named Mr. Keller who filed the complaint, but we see the complaint response that was provided by the school, and they took a letter that was given to another parent, and they say, "Dear Mr. Jones, we received your complaint." And the parent's like, "Wait, I'm not Mr. Jones, I'm Mr. Keller." So really, it's important for us to check while we're doing these things to make sure that we are not just copying and pasting what we send to everybody else. This needs to be something that we are tailoring to the individual complaints and that we're sure we're addressing the right person. Because that doesn't look good when we have the wrong parent name or the wrong student name in these particular responses. So again, checking who we're talking to is very important. It's important for us to track or to recognize when the complaint was filed. Once more, that helps to track deadlines and all those our timelines for responding to complaints. If we are in, maybe you're on the 2nd or 3rd level of an appeal, they've been to the principal issued a written decision, and you're now at the superintendent level. Well, it's always nice to double check and make sure that the principal's decision was actually sent out within an appropriate timeline. And then if your policy says an appeal must be filed within 7 days or 10 days of the principal's decision, well, did the parent actually file within the appropriate timelines? So track those type of things, that's important. And then it's also important to let the parent know who is making this decision. A lot of times our policies will say, yes, level 1 is going to be the principal or designee. Well, we don't ever sign something that just says designee. We need to let people know, yeah, this is the person who considered your complaint. I did the investigation. I'm the one making the decision. So we can't be afraid to put our own names onto things if we are the ones issuing the decision. So it's important as well that the parent understands who did the investigation and who is actually making this decision.
Question.
Yes, question. All right, question is, can the investigator be the decision maker? Yes, that's totally fine. There are currently in Title IX cases, that's not the case. That's, again, totally separate. But for anything that's not Title IX, yes, the investigator can be the decision maker. That's perfectly fine. We will see a lot of challenges to that, and thank you for mentioning that, but we see a lot of challenges to that in expulsion decisions, where a lot of times maybe your principal did the initial investigation or helped with the investigation of the disciplinary incident, and then the principal is also your decision maker for the expulsion hearing, where they're the ones making the decision. And parents will complain, well, that's not fair. Your principal did the investigation, so he's already made up his mind, or she's already made up her mind. She's not going to be fair and impartial as the hearing officer for making the expulsion decision. It may not always look great to the parent, but we can have our principal be the same person who makes that expulsion decision. And the courts have recognized that. Again, in the school context, we are not a court of law. We don't need to have a jury of 12 of our peers who are impartial, or we don't need an impartial judge. We are still a school system. We don't have unlimited resources. We don't have, extra people to do all these different things, so we are able to have our investigator be our decision maker. So. Very long-winded way of answering your question, but hopefully I did answer that. Okay. When we're making our grievance decisions or putting our written decision together, if we had a grievance conference, acknowledge when the conference occurred. That can be important. Just again, to let the parents know, yes, this is what all we did. We met on this day at this location, and then we identify who was there. If they had an attorney there, say, yeah, you were represented by your counsel, Mr. Keller. And we could also say the school's attorney, Mr. Keller, was there, although I'd never represent both sides in that circumstance. But yeah, be sure that we list out when it was that we actually met with the parent, who was there, And then it's also important for us to acknowledge what the parent is asking for. Are they asking for somebody to be terminated? Are they asking for a disciplinary decision to be overturned or rescinded? Are they asking for curriculum materials to be changed? Whatever it is the parent is asking for as a remedy, we need to acknowledge that and include that in our decision. And it's also important to help them recognize that they've been heard, to recite or kind of summarize what it is that they are claiming. We don't need to, again, copy and paste everything they include in their complaint form, but we do need to summarize to show them that, yes, I heard you. I understand what it is that you are complaining about or what your concerns are. And again, I heard you. I know what you're talking about. And then we respond. It doesn't need to be a dissertation, but we need to make sure that for each of those issues that the parent has brought, we have a fact-based and honest response to those particular concerns. And then we ultimately need to make a decision too. We can't just say, we met on this day, this is what we talked about, this is what you want, thank you very much, Alan Keller. Well, no, we need a decision. We need to say whether or not we're going to grant a particular request for relief, or if we're going to allow or deny a particular issue that they've raised. So again, have that little statement at the end where we either uphold or deny the requested remedy or what it is they're looking for. Sign and date it, that's a big one. Again, just for documentation purposes, so we can show that, yes, the decision went out on this day, so we can show when things happen to keep track of timelines. And then continue kind of tracking those appeal deadlines in your policies as well. All right, so now we're going to go through a couple of potential scenarios of things that could happen or that may reach you, or may reach you as members of administration or the board. So, all right, so Alan Keller, I'm the parent of a high school student, and I sent an email to you as the board president, and I complained that my child's school shouldn't have suspended my son from school for 2 days, and I'm demanding from you as the board president to overturn that suspension and to take it off my child's record. And I tell you that if you do not take that suspension on my record, I'm going to sue the school. What do we do? What happens? Again, you're the board president, you get this email. What do we do? Contact the superintendent. Yeah, that's a great way to do it. We know that, yes, you're the board president, people can contact you. Do you then start emailing that to all of your other board members and saying, what do we do? What should we do in this circumstance? No, that would be a violation of the Open Meetings Act, because we would be polling people and we'd be considering taking official action by email rather than during a public meeting. So yes, we would not then start deliberating by email or by text message or by phone about how to respond to this. We would let our superintendent know. We could respond back to the parents, thank you so much for your concern. We could have another brief response along the lines of, as the board president, I can't take any official action outside of open meetings, but I am going to forward your concern to our superintendent, and our superintendent will contact you with next steps. And then we can leave it at that. And then you have satisfied your obligation as the board president to receive the complaint, to respond as much as you are allowed, and to let the parent know that you can't do anything right now, but you are going to let the appropriate administrator handle those things. Because as we talked about before, there are levels to our grievance process. And folks can't necessarily just jump all the way from 0 to the board of directors automatically. They do need to follow our process. And so we can let the superintendent know, and then we can kind of go back and consider, do we need to kick this back down to the principal to start at level 1, and then go to the superintendent and finally to the board. But again, you as the board president, you are not going to be taking official action just because a parent contacts you and tells me, take that suspension off my child's record. All right, so the next one. Again, I sent an email to you as the board president, and I'm complaining that my child's teacher has been using racially insensitive language in the classroom, and that the teacher is issuing disciplinary consequences to children who look like my child more often than children who do not. I'm demanding that my teacher's child be fired, and saying that I'm going to be filing a complaint with TEA, with the Office of Civil Rights, with the EOC, with NLRB, with every other little alphabet soup organization or agency that I can think of. And ultimately, I'm going to go to the courts, or the ultimate arbiter of truth and justice, I'm going to go to Judge Judy, right? That's where we're going to end up. So what do you as board president do in that circumstance? A little bit more serious than just a a more minor suspension on my child's record, what do we do here? What policies could possibly be impacted or affected by this particular complaint?
Well, I think you would do the same thing, refer them to the superintendent, but I think that I might offer to set up that meeting with the superintendent for the parent or something, so that they could feel heard and that conversation could happen quickly.
Yeah, we've got lots of federal law that prohibit discrimination, right? And so we've got Title VI, which says that we can't, and when we're implementing our educational programs or public services, we can't discriminate based on race or national origin, which it sounds like that's what the parent is complaining about, right? You've got a teacher potentially using racial slurs or inappropriate racial language, or treating one demographic range of students differently than others. Well, that's not okay if that's actually happening. So this is serious. We need to make sure it's taken care of. So yeah, this is one where, again, we notify the superintendent and we follow up with the superintendent. Like, what's happening? Have you done anything on this? Have you reached out to the parent? If not, do I need to reach out with you to try and get us together to talk about this? Because this could end up in lots of serious places. Not quite Judge Judy, but yeah, we could end up with a TEA complaint. We could easily end up with an OCR complaint. And if we have a teacher who is using racially inappropriate language or disciplining people because of how they happen to look or where their families come from, that's not okay. And we probably need to be making a staffing change at that point if our teachers are acting that way. So again, if you're on the board and you get a message like this, you're not going to put it on the agenda for the next board meeting, most likely. You're going to respond, again, thank you for your concerns. We take the safety of our students very seriously. We're committed to having an open school setting where we respect all students, all those type of things, and we're going to give this to our superintendent or administration for handling throughout our complaint process. And once more, we go back down to the initial level of complaint process, and then if things are not resolved, by the time it actually gets to you as board members, you have a record. So you know, here's who the superintendent, who's the principal talked to. Here's the statements that we got from teachers. Here's the statements we got from students who can either kind of corroborate or say, well, no, I never heard my teacher say anything like that. Or we've reviewed the disciplinary records and we can say that, no, we are consistent in how it is that we are disciplining students regardless of their national origin or their race or anything like that. All right, this Mr. Keller is a real problem parent. He is making lots and lots of complaints. So here, I sent an email to my son's teacher, and I complained that the school library has some materials that are wholly inappropriate for children. I know that Joe Joyce in the last session talked about some of the library materials and things like that. And I am now demanding that those materials be removed immediately from the school library. What does your teacher do? Yeah, superintendents, lucky you, right? This is your lucky day where you just get to be the next in the chain. But yeah, generally we would say that a teacher is not necessarily going to be in charge of your school library. But when a parent raises a concern like this, well, it's a complaint, it's a concern, we need to address it somehow. And so we send it to the next appropriate administrator. So whether it's the principal, or if you have a curriculum person, whoever it is who's kind of in charge of the library system, yes, that is who that particular message would go to. So I will get to go to that particular individual. Okay, just a few more slides here. I'm now sending an email to my child's principal complaining about an incident that occurred in PE. I'm saying that, my son was playing basketball, they were playing basketball, and while they were playing, one of my son's classmates set a very solid screen. My son was trying to run through it and happened to separate his shoulder and broke his nose or got a black eye because of that. And so now I, as the parent, I am saying it's cost me who knows how many thousands of dollars to go to the ER or go to the doctor to get my child's or get my son's shoulder unseparated, for lack of a better phrase, or to get his nose reset, whatever the case may be. And you, charter school principal, superintendent, whoever, you school now owe me all the money that I spent in getting my child's medical bills taken care of. And on top of that, I want you to expel the student who set that screen on my student and caused him to be hurt. Well, what do we do in that circumstance? Who gets to be, call the attorney, that's right, yeah, exactly. Perfect answer. Well, I know that we talked, or you had talks earlier today about appropriate use of public funds. Are we generally able to use public money to pay for private medical expenses? No, that's something that generally we are not going to be able to do. Of course, we are never going to tell the parent that's what insurance is for. We're not going to be, unkind in that way. But we would have to come up with a response that essentially we're really sorry. We sympathize with you. However, we are not able to use our funds. The only way that we could possibly do that is if you brought it to your board as a specific agenda item, and you ask for your board to make specific findings or have a resolution saying that spending this money to pay for these private medical expenses is necessary in the conduct of your public schools, which may not be the case. So again, we are usually not going to be able to actually use our school funds to pay for a student's injury. And we do see this very often because yes, we know that kids in PE, they get hurt. There's twisted ankles, there's sprained thumbs. There's worse things, children with broken bones. We've seen those type of letters as well. We get letters very often from families' attorneys claiming you owe us lots of money for these medical expenses. And we have to write them back and explain, well, again, we sympathize with you. We hope your child is fine, but we are not able to pay for those things. What do you tell me about my request to expel this other student from the PE class?
We'll investigate to see if there was any malintent or if he was just an accident.
Yeah, just say we'll review it. And we also kind of have to make clear that we will take action as allowed by our code of conduct if we find that something wrong was done. But then we're also not going to be able to share with you what happened because, FERPA tells us we can't share that type of information. So I, as the parent, may not like hearing that, but that really is what the law requires of you. You're not able to pay for my medical expenses, and I'm not able to be fully informed of everything that happens to this other student, if anything at all. Okay, I think I've got one more. So this will be our last one of me being a complainer. We've kind of talked about some of these before. Yes. Yeah, Mr. Keller, vote with your feet and take your feet somewhere else, right? So, take your feet. Yes. So this kind of goes along with some of the ones we've talked about before, but my child was expelled from school for bringing alcohol to school. The superintendent's reviewing it. That's kind of where we start off that appeal process for our expulsion. The superintendent looks at it. And I'm arguing that I didn't get notice that my son brought alcohol to school. Like I didn't know that was something that was on the docket here. And as you investigate, as you review the files, you realize that when the expulsion hearing notice went home to the parents, it says that we thought your son brought e-cigarettes or vaping devices to school. And then when I listen to the recording of the expulsion hearing, I hear where the evidence, or I review the footage or whatever it is, I look at the evidence and I find out, well, no, there's nothing in here about e-cigarettes. And maybe Alan's son didn't have e-cigarettes at school, but instead he had a bottle of alcohol that he brought from home and he was sharing it at lunch with his classmates. Well, in that circumstance, how do we respond? What do we do there? Any ideas?
Can he appeal it to the board then? Because he's already
After the superintendent gets to review, and then if the parent doesn't like it, we get to go to the board.
Right.
Yeah, but if you're the superintendent, what do you do in this circumstance?
Look at the handbook and
Yeah.
see.
I would look at the code of conduct. And the code of conduct tells us that if we're going to expel, we have to get notice of the expulsion. And that expulsion notice has to specify what provision of our code of conduct was violated. And that's kind of like an agenda item for a board meeting. If we don't list a particular code of conduct offense in that expulsion notice, we can't then, after the hearing, go back and add things on and say, oh, well, the evidence doesn't show that you had a vaping pen or a vape pen at school, but you had alcohol. Well, no, our expulsion hearing notice says e-cigarettes or vaping devices, not alcohol. So we can't support, or we would have a difficult time supporting that expulsion decision if we didn't actually notice possession of alcohol in that expulsion hearing notice. And so that could be one where we don't want to reverse a decision because my kid brought alcohol to school. Like, we have it. We confiscated the bottle. The teachers were drinking it in the break room after school, so everybody confirmed that, yes, it was alcohol. Those type of things. Where, yes, we know it happened. He violated the code of conduct, but we're likely going to have to reverse that expulsion because we did not follow the appropriate procedures. And I don't think you as the board members want to have an appeal come to you and have your superintendent tell you, well, yeah, we messed up. We didn't follow the right process, and now we're asking you to support us in continuing this disciplinary decision when we didn't do the appropriate things to begin with. So again, there's lots of moving parts that come to parent concerns. Sometimes they're fairly simple to get through. Sometimes they're very complicated because these are their kids. These are their babies. They want their babies to be safe. They want them to feel heard. And if they feel like we aren't doing things fairly, they're going to let us know about it. And we do have a real obligation to make sure that we are being upfront with them, that we're being honest, we're being fair, and that we're taking care of their concerns. Because ultimately, if they don't like us, they're going to go somewhere else, and then we have no students to educate. And that's not going to be good for your school. So, all right, that was it. It's before 6:30, so that's good.